Bizarre Law Files. Episode 2, Trial by Ordeal. In the year 1215, a man accused of theft was brought to the edge of a pool of still water. His hands were bound. A priest read a prayer over the water. The prayer was a formal legal declaration, not a blessing, not a ritual, but a binding instruction addressed to the water itself. The instruction was this: if the man was guilty, the water was commanded by divine authority to reject him, to push him back to the surface. If he was innocent, the water would accept him, pull him down, swallow him. The man was thrown in. The crowd watched the surface. The water decided, and whatever it decided was entered into the court record as a legally binding verdict. This was not a superstition practiced in secret. This was not the action of an uneducated mob. This was the formal judicial procedure of courts operating across England, France, Germany, and most of Western Europe for more than 400 years. It was called trial by ordeal. And it was the law, the logic behind the impossible. To understand trial by ordeal, you have to set aside everything you know about how evidence works. Modern courts operate on a straightforward principle. Evidence is gathered, witnesses testify, arguments are made. A judge or jury weighs what they have heard and seen and arrives at the most reasonable conclusion. The process is human. The reasoning is human. The verdict is human. Medieval courts, for a significant portion of the Middle Ages, operated on a completely different principle. They believed that in cases where human reasoning could not reach a reliable verdict, where there were no witnesses, where the evidence was contradictory, where the accused denied everything and nothing could be proven, God would provide the answer. Not metaphorically, not as a comfort, literally. God would intervene in the physical world and make his judgment visible if you created the right conditions for that intervention to occur. Trial by ordeal was the mechanism by which those conditions were created. The underlying theology was precise and carefully argued. Medieval legal and theological scholars did not believe that God randomly intervened in human affairs. They believed God was bound by his own nature to uphold justice. That when justice was genuinely sought, when the proper ritual had been observed, when the church had sanctified the proceedings, when the community had fasted and prayed as required, God could not remain silent. His justice would be expressed through the physical outcome of the ordeal. This meant the ordeal itself was not a punishment. It was a question, a formally posed, ritually prepared, legally binding question addressed directly to God. And the physical outcome, whether the water rejected you, whether the burn healed cleanly, whether the iron blistered your hand, was God's answer. This philosophy was not invented in a dark corner of superstition. It was developed and defended by some of the most sophisticated theological minds of the medieval period. It was written into church law. It was practiced by clergy. It was overseen by priests who genuinely believed that what they were doing was giving God an opportunity to speak. The church endorsed it, the courts required it, the communities witnessed it. And for 400 years, across most of Western Christendom, it was considered the most reliable method of determining guilt or innocence in cases where no other evidence was available. There were several forms. Each one asked the same question in a different way. Each one waited for God to answer. We will examine 3 of them. Ordeal 1, the Ordeal of Cold Water. The Ordeal of Cold Water was the most widely practiced form across England and Northern Europe, and it left behind the most extensive documentary record. The procedure was standardized. It was not improvised from village to village. It was a formal legal process with established steps that were followed consistently across jurisdictions. It began before the ordeal itself. The accused was required to fast for 3 days before the proceeding. No food, limited water. This was not cruelty, it was preparation. The fast was understood as spiritual purification, a stripping away of the ordinary so that divine judgment could operate without interference. On the day of the ordeal, the accused was brought to the designated body of water, a pool, a pond, or a constructed pit specifically maintained for this purpose in some towns. The local priest was present. Court officials were present. Witnesses from the community were present. The priest performed a formal exorcism of the water. This step is worth pausing on because it reveals exactly how seriously the medieval legal system took this procedure. The exorcism was not casual. It was a legal act. The priest, speaking on behalf of the church and therefore on behalf of the divine authority the church represented, formally commanded any evil influence to depart from the water. He then blessed it. He then addressed the water directly, speaking to it as one speaks to a witness being sworn in, and formally instructed it to behave according to God's will, to accept the innocent, to reject the guilty. The water had been legally deputized. The accused was then bound, hands tied to feet in a specific configuration that prevented swimming, and lowered into the water on a rope. The court watched the rope, they watched the surface. The logic was counterintuitive to the modern mind, and it requires careful attention. Sinking was acquittal. Floating was guilt. The reasoning was theological. Water that had been blessed and exorcised was considered to have been brought under divine authority. Holy water, it was believed, would recognize innocence and draw it in, accepting a guiltless person as part of God's creation, pulling them down into the deep. A guilty person contaminated by sin would be rejected. The holy water would not accept them. They would float. This meant that in a trial by cold water, the result you wanted was to sink. The result you feared was to float. Court records from England in the 12th and 13th centuries document this procedure in detail. Sheriffs were paid for organizing ordeals. Priests were compensated for presiding over them. The results were recorded and filed the way any verdict would be filed. One surviving record from England documents more than 100 cold water ordeals conducted over a period of several decades. The results show something striking. The majority of accused persons sank. Whether this reflects genuine outcomes, or the weight of the bound configuration, or the depth and temperature of the water used, or conscious manipulation of the results by officials who knew what outcome the community expected, the historical record does not resolve. What it resolves is that people submitted to this, voluntarily, because they believed it, because the alternative, refusing the ordeal, was itself considered evidence of guilt. A person who would not submit to God's judgment had something to hide. The Ordeal of Cold Water was abolished in England in 1215, when the Fourth Lateran Council, the same council that also happened to be meeting that year, formally withdrew church authorization for all ordeals involving clergy participation. Without the priest, the procedure had no legal standing. Without legal standing, the water could no longer speak. The courts were left to find another way. The accused who chose the water. It is worth pausing to consider what it meant to be an ordinary person brought before an ordeal proceeding in 12th century England. You have been accused of something, theft, assault, perhaps something more serious, perhaps something you did not do. There is no forensic evidence. There were no witnesses. The person accusing you is more powerful than you are, or simply more convincing to the officials who matter. The ordinary legal process cannot resolve the dispute, and so you are brought to the water. You have been fasting for 3 days. You are hungry, lightheaded, probably frightened. Around you stands your community, your neighbors, the priest you attend church with, the local officials who decide whether your family eats well or poorly. They are all watching. The priest prays over the water. He addresses it. He commands it formally and legally to behave according to God's will. And then you are bound, hands to feet, and lowered in. If you believe, and in 12th century rural England most people genuinely believed, then this is not terrifying in the way it would be terrifying to a modern person. This is clarifying. You are innocent. You know you are innocent, and now God is going to say so. The rope holds you. The cold comes up around you. You go under. Whether you float or sink depends on your body composition, the configuration of the binding, the depth of the water, the length of the rope. Variables that no theology could reliably predict or control. But the priest interprets the result, the court records it, the community accepts it. And you either walk away or you do not. The historical record contains no survivor accounts of what it felt like to submit to the cold water ordeal. The people who experienced it left no memoirs, no letters, no documents of personal reflection. We have only the official records, the outcomes, the dates, the fees paid to the officials who administered the proceedings. The inner life of the accused is completely silent. which is perhaps the most honest thing the historical record has preserved about this particular branch of medieval justice. What the abolition revealed. The Lateran Council's decision in 1215 is one of the most consequential moments in the history of criminal law, and it is rarely discussed in those terms. When the Church withdrew its authorization for trial by ordeal, it did not replace it with anything. It simply said, "We will no longer provide the clergy for these proceedings. We no longer endorse the theological premise that God speaks through these physical outcomes." And the courts were left with a question they had never had to answer before. How do you determine guilt when no one saw the crime? The accused denies everything, and God is no longer available to settle the matter. The answer, developed over the following century, was the jury. Not the sophisticated legal instrument we know today. The early medieval jury was a rough, uncomfortable, often unreliable mechanism. But it was a mechanism built entirely on human reason and human testimony. The two things the ordeal system had been designed to replace, because they were considered insufficient on their own. The abolition of ordeal did not immediately solve the problem of how to try difficult cases. It created a crisis. Courts across England and Europe struggled for decades to develop reliable alternative procedures. The jury system, the rules of evidence, the formal examination of witnesses, all of these developments accelerated sharply in the century after 1215. The end of ordeal forced the law to grow up. And it did. But before it did, there was fire. Ordeal 2, the ordeal of hot iron. The ordeal of hot iron was the form most commonly applied to women and to defendants of higher social standing, in a legal tradition where the cold water ordeal was considered more suitable for men of lower rank. This tells you something important about how the medieval legal system worked. The ordeal was not a single universal procedure applied equally to everyone. It was stratified. Your gender, your rank, your social position determined which form of divine questioning you were subjected to. The ordeal of hot iron worked as follows. A bar of iron, standardized in weight and length, typically around 3 pounds and approximately a foot long, was heated in a fire until it was red. The accused, having observed the same 3-day fast required for cold water, was brought to the church where the proceeding would take place. The priest blessed the iron. He prayed over it. He formally called upon God to reveal the truth through what was about to happen. The iron, like the water in the cold water ordeal, was being asked a question on behalf of the court. The accused was then required to carry the iron, to pick it up and walk a specified distance, typically 9 feet, marked by lines on the floor while holding the heated metal in their bare hands. After completing the walk, the hands were wrapped in cloth, sealed with the priest's seal. The accused was held for 3 days. On the 3rd day, the cloth was removed. The priest and the court officials examined the hands. If the wounds were healing cleanly, no infection, no festering, a clear and orderly progression toward recovery, the verdict was innocent. God had protected the accused. The fire had done its work without leaving the mark of guilt. If the hands showed infection, or the wounds had worsened, or the burns were severe and spreading, the verdict was guilty. God had not intervened. The fire had been allowed to speak. 3 days. That was the window in which God was given to demonstrate his judgment through the behavior of a wound. Historical accounts of the ordeal of hot iron are preserved in the records of English and continental European courts throughout the 12th century. They describe the procedure in procedural terms: the weight of the iron, the distance walked, the duration of the binding period, with the same administrative precision as any other court proceeding. One account from a 12th century English chronicle describes a woman accused of poisoning her husband who walked the iron distance and was subsequently found to be healing on the 3rd day. The record notes her acquittal without apparent doubt or editorial comment. The ordeal was the verdict. The verdict was recorded. The case was closed. What strikes the modern reader is the 3-day window. Medieval courts were, in effect, giving infection the weekend to develop before making their decision. Whether that produced reliable outcomes depended on the depth of the burn, the cleanliness of the cloth, the state of the accused's immune system, and the interpretation of the examining priest. Different priests in different jurisdictions almost certainly had different thresholds, for what constituted clean healing versus guilty festering. The ordeal was standardized in procedure. It was not standardized in interpretation. And interpretation, in the end, was everything. The priest at the center. There is a question historians have been asking about trial by ordeal for more than a century, and it does not have a comfortable answer. Did the priests know? The priests who presided over ordeals were not bystanders. They were active participants. They blessed the water. They prayed over the iron. They examined the wounds. They delivered the verdict. They also knew, in many cases, whether the community believed the accused was guilty or innocent before the ordeal began. Several medieval scholars have argued, based on the statistical patterns in ordeal records, that priests were actively managing outcomes. That when community sentiment strongly favored acquittal, the iron might have been slightly cooler, or the wound might have been examined more generously. That when guilt was broadly assumed, the interpretation of the results was correspondingly harsher. This is not provable. The records do not say, "I heated the iron less because everyone in the village knew she hadn't done it." But the records do show statistical patterns that are difficult to explain purely by chance. And if the priests were managing outcomes, if they were using the theater of the ordeal to ratify conclusions the community had already reached, then the ordeal was not revealing God's judgment. It was revealing the community's judgment, dressed in the language of God. Which raises a question that medieval courts never had to confront because they never asked it. What is the difference? Ordeal 3, trial by combat. Not all ordeals asked their questions through fire and water. Some asked them through blood. And of all the forms that trial by ordeal took across the medieval and early modern period, none lasted longer, none crossed more legal and cultural borders, and none came closer to surviving intact into the modern world than the one that settled disputes with steel. Trial by combat, also known as judicial combat or wager of battle, was a form of ordeal in which the guilt or innocence of an accused person was determined by the outcome of a formal, legally regulated fight between two combatants. The theological premise was the same as every other ordeal. God would not allow an innocent person to be defeated. The righteous cause would prevail. Victory in the combat was victory in the case. The procedure was as formalized as any other legal proceeding. Both parties or their appointed champions, since the right to appoint a representative fighter was recognized in many jurisdictions, would appear before the court on the appointed day. They would make formal oaths before God attesting to the justice of their cause. Then they would fight. The weapons were regulated. The duration was sometimes regulated. The location was designated. Officials observed. The outcome was binding. In civil disputes, disagreements over land, debt, property, trial by combat allowed the aggrieved party to challenge the defendant to a fight rather than submit their case to the ordinary courts. If you believed the law would not give you justice, you could take your case to God's judgment directly, through your sword arm or the sword arm of the man you hired to represent you. This created an entire professional class of fighters who made their living as judicial champions. Men who could be retained by anyone, nobleman or commoner, woman or man, who had a case to bring and the means to pay for a representative. The church, despite endorsing most forms of ordeal, had complicated feelings about trial by combat specifically. Its violence was difficult to reconcile cleanly with Christian teaching. Several church councils debated the procedure's legitimacy throughout the 12th and 13th centuries. The complications did not stop the practice. One of the most extensively documented judicial combat cases in English history took place in 1456, more than 200 years after cold water ordeal had been abolished. A dispute over land between two men named Thomas Whiting and John David was submitted to trial by combat in London. Both men appeared on the appointed day. Both were equipped with the designated weapons. Both made their oaths. The fight lasted long enough that both men were exhausted, bloodied, and barely capable of continuing. At some point during the combat, the court officials called a halt. Both men had performed. Neither had definitively won. The case was settled by negotiation. God had apparently declined to give a clear answer. Trial by combat was technically legal in England until 1819, when Parliament finally abolished it following a case in which a defendant, charged with murder, challenged the victim's family to judicial combat to settle the matter, and the court realized with some embarrassment that it had no legal grounds to refuse. More than 600 years after the Lateran Council began dismantling the ordeal system, an Englishman nearly had his murder charge settled by a sword fight, because the law had never quite gotten around to closing the door. What trial by ordeal tells us about justice? The ordeal system did not survive because people were ignorant. It survived because it solved a problem. The problem was this: in a pre-modern society, before forensic science, before reliable witness testimony could be systematically gathered and evaluated, before any of the evidentiary tools that modern courts take for granted, how do you determine guilt in a case where no one saw what happened? The honest answer in many cases was, you cannot. The ordeal did not pretend otherwise. It acknowledged that human knowledge was limited. It acknowledged that some cases were genuinely beyond the ability of human investigation to resolve. And it proposed that in those cases, the appropriate response was not to guess, not to make the most powerful person's accusation stick, not to acquit everyone who could not be proven guilty beyond doubt, but to ask a higher authority. The willingness to submit to ordeal was itself informative. An innocent person who believed genuinely in the theological framework had every reason to submit. God would protect them. An innocent person who refused the ordeal was either a non-believer or someone who did not trust God to speak truly, both deeply suspicious positions in a medieval community. A guilty person, meanwhile, knew that God knew the truth. Submitting to ordeal meant trusting that God might overlook what you had done, or that the priest might misread the wound, or that the water might malfunction. In a society that genuinely believed in divine judgment, the ordeal was not irrational. It was a very efficient sorting mechanism, one that worked as well as it did precisely because nearly everyone believed it worked. The moment people stopped believing it worked was the moment it stopped working. And that moment arrived in 1215. When the Church withdrew its authority from ordeal proceedings, it was not making a statement about physics or theology. It was making a statement about institutional confidence. The Church no longer wanted to be responsible for outcomes it could not control. It no longer wanted its priests to be the mechanism by which an ambiguous wound became a hanging. The withdrawal of clerical participation was the withdrawal of belief. And belief was everything the ordeal had ever run on. The question the ordeal could not answer. There is one final thing about trial by ordeal that rarely appears in the legal history textbooks, because it is uncomfortable to say clearly. In many cases, the ordeal probably got it right. Not because God intervened, not because the water had divine perception, but because the communities that administered ordeals were small and interconnected in ways that modern legal systems are not. The priest who examined your wound had baptized your children. The court official who recorded your verdict had eaten at your table. The witnesses who watched your ordeal had watched you live your life for years. In a community that small, genuine guilt was rarely invisible, people knew. They often knew before the ordeal began who had done the thing and who had not. The priest, interpreting an ambiguous wound, was not operating in an informational vacuum. He was operating in a social environment saturated with shared knowledge, shared reputation, shared history. The ordeal gave that knowledge a legal form. It gave the community's judgment the cover of divine authority. This does not make it just. A system that produces correct outcomes for the wrong reasons is still a system built on a wrong foundation. And it produced catastrophically incorrect outcomes often enough, convicting the innocent, acquitting the guilty, depending on who the priest liked or feared or owed favors to, that its replacement was necessary and correct. But the historians who look at the ordeal records and see only primitive superstition are missing something important. They were not just asking God, they were asking each other. They just needed a procedure that looked like they were asking something higher. The aftermath. The century following 1215 was, in legal terms, one of the most creative and chaotic periods in Western history. Courts that had relied on ordeal for generations suddenly had nothing. Accused persons who had previously been able to demand God's judgment were now left with human judgment, which was slower, more expensive, more corruptible, and less final. England moved fastest. The jury system, already present in a rudimentary form in some civil proceedings, was expanded into criminal trials. Defendants who refused to accept a jury verdict could be subjected to peine forte et dure, literally, strong and hard punishment, in which heavy weights were placed on their bodies until they either agreed to be tried by jury or were crushed to death. The coercion required to make the jury system work in the immediate post-ordeal period was, in some respects, more brutal than the ordeal itself. But the direction of travel was clear. Human reason was taking over from divine intervention as the operating principle of criminal justice. The process was slow, it was imperfect, it produced terrible outcomes for generations. It also produced something the ordeal system had never been designed to produce: consistent, reviewable, improvable procedure. A verdict from an ordeal could not be appealed on the grounds that the water had made an error. A verdict from a jury could be challenged. A judge's reasoning could be questioned. A procedure could be reformed when it produced obviously wrong outcomes. The replacement of ordeal by human procedure did not immediately make justice better. In many cases, it made it worse. But it made it correctable. And correctable over time is the most important thing a legal system can be. This wasn't myth. It was law.